first of all, I have no relationships to disclose. We were asked to show that slide, except for my wife, who's here today. Now we'll disclose that. Glad she could make it. And we're so happy to be invited to a meeting in warm Phoenix after scraping the ice off our windshield yesterday morning in Cambridge. Thank you for the invitation. I've been a lawyer for a long time. I had my first mesothelioma case come to my office in 1978, and since then, I and my office have represented over 1,000 victims of mesothelioma. We're very much aware of the gravity and the nature of this disease. So from a legal perspective, you have a victim of asbestos disease, and that is usually one of the signature diseases, which is mesothelioma or asbestosis, but also lung cancer, also cancers of the gastrointestinal tract. But we'll focus today on first asbestosis and then mesothelioma, just to show you what the legal picture is on this. You have the victim. What we're there to do is to get compensation, get money from the manufacturers that manufactured the asbestos that made our clients sick, for them and their family if it's possible. The standards in product liability law vary from state to state in the United States, but basically they say this: if you manufacture a product, you've got to make sure that it's safe. You just can't send it out there if it's hazardous, if it's toxic. You must test it. You must put instructions along with it on how to use it safely if there's a problem in that regard. You must warn if there are hazards associated with the use of the product. And finally, you must not use it at all if it is hazardous, if it is toxic, and if there's a safe alternative. We have said that the manufacturers of asbestos products in fact did none of those things. Their defense has been basically, for over the years, these many, many years, that they knew nothing about the hazards of asbestos exposure, and therefore they weren't, and their tests were fine, and therefore they weren't required to warn, and they were free to use asbestos in their products. Someone's telling the truth and someone's not here. I brought along today some evidence that we use, and you might see some evidence markers on these documents, to prove that, in fact, they knew a lot more than they're admitting, and they should be held responsible to compensate the victims of their conduct. We start off in the 1935. This is Asbestos Magazine was a trade journal in the insulation industry, and this is a letter written by the editor of Asbestos Magazine, a Miss Rossiter, to Summer Simpson, who was president of the Ray Bestis Manhattan Asbestos Company. They manufactured asbestos brakes in Bridgeport, Connecticut. She said she's requesting if they could write an article about asbestosis and asbestos disease in this journal, which is read by asbestos workers, insulation workers, and people in the... It says, always you have requested, this is in the past, that for certain obvious reasons we publish nothing, and naturally your wishes have been respected. She goes on to say, but you know, we hope, could you change your mind now? Could we print something in our journal about the dangers of asbestos? This letter was quickly forwarded to Summer Simpson's friend, Van Diver Brown, who was the head attorney at Johns Manville for decades, and was a real key player in this thing. And in the correspondence between the two in October 1935, they agreed that our interests are best served by having asbestosis receive a minimum of publicity. Now, that's one way they did it. You didn't find any evidence of dangers of asbestos in trade journals or stuff in which people which were occupationally related to asbestos would be able to have an opportunity to inform themselves. And the second way was that they controlled the research. This is a letter from F.M. Schulter, president of Thermoid Rubber Company, which became the GAF company, was a big manufacturer of asbestos siding and roofing materials. They had a asbestos mine up in Vermont, as a matter of fact. Most of the asbestos mines in the United States were in Canada. The last one was shut down within the last year in Asbestos, Quebec. So on November the 11th, 1928, Mr. Schulter says, my own idea is it would be a good thing to distribute the information among the medical fraternity, that's you guys, providing it was of the right type and would not injure their companies. In other words, they were preparing to sponsor a study of the dangers of asbestos. But one of the things, and there was the companies that were involved, and you see John's Manville, you can't see any of this stuff, you're going to take my word for it, because these documents are old and they're not very clear, I apologize for that. And 5 other companies, they sponsored a study of the dangers of asbestos. But one of the things they always said was, we insist on having control over publication. And in fact, they go beyond that. They also had control over editing of these things if they were published at all. This is another study which was sponsored by the asbestos industry, and this was in the 1940s, and it was at the Lake Saranac Institute in Lake Saranac, New York. That was, as many of you probably know, was one of the most prominent institutions in the world for the study of pneumoconiosis. And Vandiver Brown, back at this time, this is in the 1940s, says, it is our further understanding, and he's writing to Leroy Gardner, who was, at that time, Dr. Gardner was the president of the Institute. He said, it is our further understanding that the results obtained will be considered the property of those who are advancing the required funds, who will determine whether, to what extent, and in what manner they shall be made public. In the event it is deemed desirable that the results are made public, the manuscript of your study will be submitted to us for approval prior to publication. And in addition to reviewing it, they actually edited it. And Vandiver Brown and a couple of his colleagues, the other asbestos companies, wrote a number of articles for medical journals over the years that came out under the head of prominent researchers. Dr. Gardner's stuff was never, actually, Dr. Vorwald's stuff was never, Gardner's stuff was never allowed to be published at all. He died in 1946, and he was replaced by Dr. Vorwald, Arthur Vorwald, and he had similar treatment from the asbestos manufacturers until he was finally let go in 1953. But that's one of the reasons why you didn't see too much in medical journals in the United States in particular concerning the dangers of asbestos. And incidentally, I'm talking about asbestosis for the most part here. The law is, we're talking about the law, is it's not, is that you just can't, you have to warn about asbestosis and not mesothelioma. In other words, if your product's dangerous, it's dangerous, whether it causes asbestosis, whether it causes lung cancer, whether it causes mesothelioma. It's all the same. If you've got a dangerous product, you've got to warn and you've got to instruct, or you've got to use a safe product. This is poor Dr. Gardner writing back in 1936 on another study to, again, our friend Vandiver Brown at Johns Manville. The Saranac laboratory agrees that the results of these studies shall become the property of the contributors, and the manuscripts of any reports be submitted for approval of the contributors before publication. Leroy Gardner, Saranac Laboratory. And remember, the companies didn't know anything about the dangers of asbestos because there was nothing being written. That's one of their main defenses. This is another product, Kalo, which is a very big asbestos insulation product here in the United States in the 1940s, in the 50s, in the 60s, and right into the 70s, actually. It was manufactured initially by Owens, Illinois. Later was acquired by Owens Corning, and they continued for many more years. So when they tested it at the Saranac Laboratory in 1948, Dr. Vorwald, who had replaced Dr. Gardner, wrote back to U.E. Bose at the Owens, Illinois Glass Company and said, sadly, well, initially they thought that the product was fine, it was safe when they did the animal studies, but that was with 30 months or less of exposure. Of course, there's a certain latency in animals, as in humans, and that's so no results were valid up to that point. But as it turns out, when they went beyond 30 months of exposure, unmistakable evidence of asbestosis is developed, showing that Kalo on inhalation is capable of producing asbestosis and must be regarded as a potentially hazardous material. Believe me, Dr. Vorwald wasn't happy to give Mr. Bose this information. But he goes on to say, I realize that our findings regarding Kalo are less favorable than anticipated. However, since Kalo is capable of producing asbestosis, it is better to discover it now in animals rather than later in industrial workers. Thus, the company, being forewarned, will be in a better position to institute adequate control measures for safeguarding exposed employees and protecting its own interest. Again, November the 16th, 1948, You can't imagine how much K-Lo was sold in the United States between 1948 until it was finally withdrawn from the market in 1972. And neither Owens, Illinois, or Owens Corning ever did a damn thing with this information they had. This is a affidavit by Charles Romer, who was actually a lawyer. And it was he was telling about his cousin who worked, Jacob Romer, who worked as a physician in the Unarco plant in Paterson, New Jersey. Unarco manufactured an asbestos pipe covering called Unibestos, which is another big seller. And I'm going to, that's indecipherable. I can read that, I think. They start having a problem with asbestosis among their factory workers, and they didn't really know what to do with it. They thought probably the best thing to do was to get them out of there, but they thought maybe they'd go to the big company in the business, Johns Manville, which was over in New York, where the corporate headquarters were, and ask what they should do about it and what Manville does about it if they had problems with workers developing asbestos-related diseases. This included cancer, incidentally, beyond asbestosis. And this is the affidavit, Charles Romer. You can see his signature over on the right. He signed that in 1982, talking about that conversation they had back in the 50s about the Paterson, New Jersey plant. And he died shortly after that affidavit was done. That's why we don't have a deposition of him. But he said, Vandiver Brown said it was Johns Manville policy not to do anything, nor to tell the employees of the X-ray findings. They had asbestos disease too, but they were keeping it on the low. It was foolish for us to be concerned that if Johns Manville workers were told they would stop working and file claims against Johns Manville, and then it was Johns Manville policy to let them work until they quit work because of asbestosis or died as a result of asbestos-related diseases. That's the 1950s, and that was still the official line, quietly, under the radar of the asbestos industry. Remember, they didn't know anything about asbestos disease. This is another trade journal, Petroleum Engineer. There was an article written about a new product that Owens, Illinois had, hydrous calcium silicate heat insulation. It's April 1952. E.C. Schumann was an employee and read it. You can see on the upper left-hand corner, there was in that same article, the guy was showing you how to use the pipe covering, how you could saw it. It had 15% asbestos was in it, and the reason why it's kind of difficult to see is there's so much dust coming off that sign of that pipe that it clouded the picture. You don't see any respirator on that worker, you might notice, and this is the way they should do it. They only mentioned in the entire article in 1952, and they knew this stuff was dangerous, was that they said the applicators appreciate the fact that hydrous calcium silicate is non-toxic and easy on the hands. Well, it was easy on the hands compared to fiberglass, which of course is a much safer product, but it certainly wasn't non-toxic, and it resulted in many people contracting asbestos-related diseases over the years. With regard to when companies knew not just that asbestos caused asbestosis, but cancer, lung cancer and mesothelioma, the articles actually started earlier than you might think. It was initially case reports. Wedler in 1943 had 2 case reports, asbestos considered to be the cause of pleural mesothelioma. It wasn't just Dr. Selikoff after all, although we'll mention him in a while. He did an awful lot, Dr. Flores. We can see the annual report of the Chief Inspector of the Factories for the year 1947, 1949. This is the English studies. Cancers of the lung and pleura counted together in demonstrating excess incidence among asbestotics. Doig, in 1949, review article mentions cancers of lung and pleura in asbestos workers. The Lichter article, it was a case report in 1954, asbestos considered the cause of peritoneal tumor in asbestos factory worker. Report abstracted in Bulletin of Hygiene. Dahl, in 1955, endothelioma of the pleura counted among the pleural pulmonary cancers. This goes there's numerous articles. They're from all over the world, mostly in Europe. Not that many in the United States, but we do read European journals here. And of course, by 1960, everyone knew. Skeepers Garrett Skeepers actually included in a reference to mesothelioma and asbestos disease in text on occupational lung diseases. Wagner did a lot of the initial studies. There's a 33-case study in South Africa on pleural mesothelioma and exposure to asbestos. And actually, the asbestos companies continued to do their own testing of this stuff. This was a test done in the late 40s by, under the supervision of Kenneth Smith. He became the medical director of Johns Manville, and it was done in an asbestos mine up in Quebec. And they got the results, and sure enough, an awful lot of people were developing asbestos disease. And Kenneth Smith, Dr. Kenneth Smith, said it must be remembered that although these men have X-ray evidence of asbestosis, they are reporting today and definitely not disabled from asbestosis. They have not been told of this diagnosis, for it is felt as long as the man is happy at home and at work, and his physical condition remains good, nothing should be said. When he becomes disabled and sick, then the diagnosis should be made and the claim submitted by the company. The fibrosis of this disease is irreversible and permanent, so eventually compensation will be paid to each of these men. But as long as the man is not disabled, it's felt he should not be told of his condition so he can live and work in peace, and the company can benefit by his many years of experience. Should the man be told of his condition today, there's a very definite possibility that he would become mentally and physically ill simply through the knowledge that he has asbestosis. This is a doctor talking. This is the final slide. And this was that same doctor, Dr. Kenneth Smith, had his deposition taken, and he died like a month after this, in April of 1976. And the lawyers who took that deposition in Louisville, Kentucky, is a friend of mine. I remember talking to him about the deposition the week after he took it. He was very excited. And he said, well, Dr. Smith, he said, you've known this stuff is toxic and dangerous and causing cancers and causing asbestosis. Why didn't you at least warn? Why didn't you put warnings on the product? And Kenneth Smith said, the reason why the caution labels were not implemented immediately, it was a business decision as far as I could understand. Here was a recommendation. The corporation is in the business to provide jobs for people and make money for stockholders, and they had to take into consideration the effects of everything they did, and if the application of a caution label identifying a product as hazardous would cut into sales, there would be serious financial implications. And the powers to be had to make some effort to judge the necessity of the label versus the consequences of placing the label on the product. April 21st, 1976. The first asbestos cases brought back in the mid-70s, and when I filed my first one, there was less than 50 in the United States, were lost. And they were lost because juries believed the manufacturer's defense, and that is they didn't know that the stuff was dangerous. How could they warn about something they didn't know? And it's taken over 30 years of hard work by a lot of creative lawyers around the country to gain the evidence of what really was known back in the 20s and the 30s and the 40s and the 50s and the 60s. And sadly, what the motivation was in continuing not to warn and continuing not to make their products safe. This is not, I can tell you as a lawyer, this isn't something that, sadly, that is unique to the asbestos industry. My office also represented a lot of victims of lead, young victims of lead paint in the 80s. We represented the Commonwealth of Massachusetts in the cigarette litigation. Remember, they didn't know anything about it. Cigarettes didn't cause lung cancer. That was going into that litigation, that was still their hard line. They got up and testified it in Congress. When money's involved, sadly, sometimes people will make poor choices. And the asbestos experience and the mesothelioma experience is sadly an outstanding example of that. These people just lost their way, and as a result, you have got your hands full with a mesothelioma epidemic that's going to last for a while because asbestos is ubiquitous in our society. It's every place, and it's going to take a long time before we get rid of it. Thank you very much for inviting me today.